Preamble. The preamble of the Constitution is based on the objective resolution drafted and moved by the Pandit Nehru and adopted by the Constituent Assembly. The Constituent Assembly enacted it after the rest of the Constitution was already elected to ensure its conformity and coherence with the Constitution. It has been amended only once so far by the 42nd Constitution Amendment Act 1976 by adding three new words: socialist, secular, and integrity. It contains the grand and the noble vision of the Constituent Assembly and reflects the dreams, mind, and aspirations of the founding fathers of the Constitution. Limitations of the preamble and jurisprudence. No government power does not grant authority to the executive, legislative, and the judiciary, cannot override provisions, cannot supersede explicit constitutional articles, non-enforceable, cannot be enforced by the courts, by the government in courts. Clarification rule: the preamble itself has been vague, general, and ambiguous. Its constitutional position has itself been debatable on the courts of the justice. Constitution Day, Samvidhan Divas. Date: celebrated annually on 26 November. Purpose: commemorates the adoption of the Constitution of India in 1949 and promotes constitutional values among the citizens. Notification: the Ministry of the Social Justice and the Empowered announced this celebration on 19 November 2015. Opponents of the preamble: source of the authority, the Constitution, people of India, nature of the Indian state, sovereign, socialist, secular, democratic, and republic. Objectives: justice, liberty, equality, fraternity. Date of the adoption: 26 November 1949. Philosophy of the Constitution: Gandhi's idea of the Swaraj, self-reliance, justice, and tolerance. Significance of the preamble: it is a summary of the philosophy of the Indian Constitution and key to the minds of the Constitution maker. Supreme Court. Identity card of the Constitution: N.A. Palkiwala. Horoscope of our sovereign Indian Democratic Republic: K.M. Munshi. Sir Ernest Barker said that it is the keynote to the Constitution. Justice Sikri indication on the Bharati said that guiding light for the judicial interpretation. Keywords in the preamble: meaning and features. We the people of India emphasizes that the Constitution is made by and for the Indian people. It emphasizes the concept of the popular sovereignty, whereby citizens are the ultimate source of the Constitution authority, ensuring governance aligns with the well-being. Sovereign. Definition: it signifies that India is a solely independent state, free from the dominion or dependency of any other country. Independence in affairs: India has the authority to conduct both internal and the external matters without interference. It can acquire foreign territories or cede parts of its own to other nations. International relations: India's full membership in the Commonwealth of the Nations with the British government as its head or joining the UNO does not compromise its sovereignty, reflecting its commitment to global cooperation while retaining independence. Socialist. Definition: socialism is an economic and the political system where the means of the production are owned collectively or by the government, prioritizing social equality. Types of the socialism: democratic socialism, characterized by the mixed economy with both public and the private sectors, adopted by the India. Communistic socialism advocates for total nationalism as prevalent in China earlier. Indian approach blends Marxism and Gandhian philosophy to combat poverty, ignorance, disease, and inequality. Gandhism and the Marxism both aim for a stateless and the classless society but differ in their approach. Marxism views the state as an instrument of the oppression, serving the bourgeoisie, and the advocates for the class struggle and revolution to achieve a stateless society. Gandhism opposes even a minimal state due to its reliance on force, which contradicts non-violence. Gandhi favors running of the local self-governments instead. Addition in the Constitution: socialist nature is implicit in DPSP, Article 38, 39, 39A, 41, 42, 43, 43A, 47. But the 42nd Amendment of the 1976 is mentioned explicitly. Secular. Definition: in the Indian context, secular means equal treatment of all religion without discrimination. 42nd Amendment, the term secular was explicitly added in the preamble, established India as a secular state. Positive secularism emphasizes equal status and the support for all religions, fostering a diverse and the inclusive society. Each religion receives equal recognition regardless of size or influence. Legal standing: the concept of a secular state is part of the basic structure doctrine, and the Supreme Court acknowledged its implicit presence in Article 25 to 28, right to freedom of the religion. Democratic. Definition: democracy allows citizens to enjoy equal political rights, elect rulers, and hold them accountable. It is based on the doctrine of the popular sovereignty, where supreme power resides with the people, articulated in the preamble. Forms of the democracy: direct democracy. Citizens exercise power directly. Example in Switzerland, using referendums, initiatives, recall, and plebiscites. Initiatives: citizens propose statutes to send to the legislature or put on the ballot. Recall: voters can remove public officials before term ends. Referendum: voters accept or reject a legislation. Plebiscite: direct vote on significant issues for establishing political conditions. Indirect democracy: elected representatives govern parliamentary and the presidential systems. Indian democracy: a representative parliamentary democracy with an accountable executive. Features includes universal adult franchise, periodic elections, rule of the law, independent judiciary, and non-discrimination. Non-discrimination comprehensive approach encompasses political, social, and economic dimensions. Supreme Court Insight, 1997. The Constitution aims for an egalitarian social order, ensuring justice in India's social and the economic democracy. Note: democracy is superior versus lies in the fact that it calls into activity the intelligence and character of the ordinary man and the woman. Republic. A republic vests political sovereignty in the people and not a monarch, ensuring no privileged class and equal access to the public offices without any discrimination. Political sovereignty rests with the collective citizenry, fostering equality and inclusivity in governance. Indian Republic. The head of the state president is indirectly elected for a fixed 5 years term as stated in Article 56, source Indian Constitution. Justice. It is the idea that all people should be given fair, equal, and balanced consideration and treatment. The idea of providing social, economic, and the political justice in the preamble is influenced by the Russian Revolution 1917. Distributive justice combines social, economic, and the political justice. Social justice ensuring equal treatment for all citizens without distinction based on caste, color, race, religion, or gender. No privilege for any group aims to uplift backward classes, SC, ST, and OBC, and women. Economic justice eliminates discrimination based on economic factors, focuses on reducing inequalities in wealth, income, and poverty. So, political justice guarantees equal political rights and access to all political offices, ensures every citizen has an equitable voice in the government. Overall framework: justice is safeguarded through provisions in the fundamental rights and DPSP, highlighting its comprehensive approach. The term social capital, popularized by Robert Putnam, refers to networks with shared norms, values, and the understanding that facilitate cooperation. It includes trust, mutual understanding, and shared values that foster community and cooperative action. Literacy rates and working age population size are examples of the human capital. Buildings and the infrastructure represent physical capital. Literacy, liberty. Definition: liberty means absence of restraints on the activities of the individuals. It grants individuals the freedom to make choices and pursue activities without restrictions, promoting personal growth and development of the unique personalities. The ideals of the liberty, equality, and fraternity in the preamble are inspired by the French Revolution, 1789 to 99, where there is no law, there is no freedom. Therefore, liberty is to be free from restraint and violence from others, which cannot be where there is no law. It is said by John Locke. Preamble provisions. Sources secures the liberty of thought, expression, belief, faith, and worship, and emphasizes that liberty is not absolute. It must be exercised within constitutional limitations. Qualified, that is qualified liberty. Fundamental rights related to liberty are legally protected and more foreseeable in the courts. Types of the liberty: negative liberty focuses on the absence of the interference, ensuring individuals are free from obstacles and the constraints. Positive liberty: freedom to act in a way that allows individuals to make control of their lives and achieve their fundamental purposes, emphasizing the importance of community. Equality definition: equality signifies the absence of the special privileges and ensures equal opportunities for all individuals, free from discrimination. Preamble provisions: the preamble guarantees equality, the status, and the opportunities across three dimensions: civil, political, and the economic. Civil equality, civic equality ensures equality before the law. Article 14. Article 15 prohibits discrimination. Article 16 provides equal opportunity in public employment. Article 17 abolishes untouchability. Article 18 eliminates titles. Political inequality. Political equality guarantees inclusion in electoral rolls. Article 325 and mandates elections based on the adult suffrage. Article 326. Economic equality secures equal rights to livelihood and equal pay for equal work. Article 39, promoting a fair and the just society in India. Overall significance: the Constitution fosters a fair and the just society through this fraternity. Definition: Dr. B.R. Ambedkar defines fraternity as the sentiment of shared brotherhood and sisterhood among all citizens. Preamble provisions: it declares that the fraternity has to ensure the dignity of the individuals and the unity of the integrity of the nation by single citizenship, fundamental right DPSP, and the fundamental duties. Fundamental duties: Article 51A. Every citizen must promote harmony and common brotherhood, transcending religious, linguistic, regional, or sectional diversities. National integration: unity and the integrity addresses both psychological and territorial aspects, with Article 1 declaring that India as a union of the states to combat communalism, regionalism, casteism, linguism, and the term integrity was added by the 42nd Constitutional Amendment Act in 1976. Union of the India, Union of the Trinity. Social democracy. Principles of the liberty, equality, and the fraternity are not to be treated as separate items in the Trinity. If any of this is absent, it will defeat the purpose of the democracy. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiatives. Supreme Court cases related to the preamble. Berry Union case. The preamble shows the general purpose behind several provisions of the Constitution. Its terms used in articles are ambiguous. Some assistance from the preamble could be taken for interpretation. Supreme Court held that the preamble is not a part of the Constitution. Golaknath was the state of the Punjab case. Justice Siddhartullah asserted that the preamble contains enduring principles essential for government functioning, making it internal and the unalterable essence of the Constitution. Ishant Bharti case. Supreme Court said that the preamble is a part of the Constitution. Reversed its opinion as given in the Berry case. The preamble can be amended subject to the condition that it should not destroy the basic structure of the Constitution. LIC of India case. Supreme Court again held that preamble is an integral part of the Constitution. Sixth, states and the union territories. Constitution provisions. Article 1 defines the name and the territory of the Union of the India. Article 2 governs the admissions for the establishment of the new state. Article 2A repealed previously associated SICM with the Union. Article 3 outlines the formation of the new states and alteration of the areas, boundaries, or the names of the existing states. States. A bill for changes requires presidential recommendation after consulting the state legislature for views. Though the President, Parliament is not bound by these views. Union territories, no requirement to consult the legislature. Parliament can act independently. Article 4, law made under Article 2 and 3 to provide for the amendment of the first and the fourth schedules and supplemented incidental and consequential matters, declares that the laws made under Article 2 and the 3 are not to be considered as the amendments of the Constitution under Article 368. Important concerns regarding states and the Union territories. Union versus federation. Union of the states is used over federation of the states because Indian federation is not based on the state agreements like in the US. States cannot succeed here. Indestructible union. India is an indestructible union of destructible states, while the US is an indestructible union of the indestructible states. The US requires state consent to form new states or alter the boundaries. Parliamentary authority. Parliament can create new states or alter boundaries without consent, so territorial integrity isn't guaranteed. Territorial scope. Territory of India includes states, union territories, and future territories, while Union of the India includes only states. The Constitution does not contain any separate provisions for the administration of the acquired territories. Exchange of territories. Parliament's power. Under Article 3, Parliament can reduce a state's area but cannot cede territory to a foreign nation as ruled by the Supreme Court in 1960 regarding Bearable Union. Territorial cession. Territory can only be ceded to foreign states via Constitution Amendment Act. For example, 100th Constitution Amendment Act 2015 deals with the transfer of the enclaves between India and the Bangladesh. As a sovereign state, India has acquired various foreign territories such as Dadra and the Nagar Haveli, Goa, Daman and Diu, Puducherry, and Sikkim since the commencement of the Constitution. Transferring territory requires a Constitution Amendment under Article 368 enacted through the 9th Constitution Amendment Act 1960 for boundary disputes. In 1969, the Supreme Court stated that resolving boundary disputes does not need a Constitution Amendment Act and can be done via executive action. Exchange with Bangladesh. Radcliffe Commission demarcated boundaries at independence, neglecting small enclaves known as Chitmahals. These areas were discussed during the Bag Award of 1950 and Nehru-Noon Agreement of 1958. Enclave details 111 Indian enclaves in Bangladesh, 51 Bangladeshi enclaves in India. Change of the names of the states and the union territories. All name changes were executed under Article 3 of the Constitution of the Parliament. It included UP, Tamil Nadu, Karnataka, Lakshadweep, National Capital Territory of India. Under the 69 Constitution Amendment Act, Uttarakhand, formerly known as the Uttaranchal, Puducherry, formerly known as the Pondicherry, renamed in 2016, and Odisha, formerly Orissa. Okay. Various commissions in the reorganization of the states and the union territories. The Commission recommended state organization based on the administrative convenience, not language. Jawaharlal Nehru JVP Committee formally rejected language as the basis for the state reorganization. Members included Jawaharlal Nehru, Vallabhbhai Patel, and the Pattabhi Sitaramaya. In October 1953, the government of India was forced to create the first linguistic state known as the Andhra state by separating Telugu-speaking areas from the Madras state. Fazal Ali Commission accepted language as the basis but rejected one language, one theory, one state theory. Its recommendations led to the State Reorganization Act, creating 14 states and 6 union territories on November 1, 1956. Members of the commission: Fazal Ali, K.M. Panigar, and K.N. Kunzru. 7. Citizenship, Part 2, Article 5 to 11. Constitution provisions related to the citizenship. Article 5 to 11. Located in Part 2 of the Constitution, these provisions identify those who become citizens of the India at its government on January 26, 1950. They do not contain permanent or detailed provisions or citizenship. Article 5. Citizenship at the time of the Constitution's amendment. People who were born in India or have been residing in India for 5 years immediately before the commencement of the Constitution. Article 6. Citizenship of those who migrated from Pakistan to India and either of his parents or grandparents were born in the undivided India. Article 7. Citizenship of those who migrated to Pakistan and later returned to India and had been a resident for 6 months. Article 8. Citizenship for persons of the Indian origin residing abroad. Article 9. Termination of the citizenship upon voluntary acceptance of the other country's citizenship. Article 10. Continuance of the citizenship rights unless Parliament enacts a law. Article 11. Parliament's authority to regulate citizenship through laws. Parliament's power. Parliament is empowered to legislate on matters related to citizenship. Single citizenship in India. Definition: the Indian Constitution establishes single citizenship like Canada, meaning all citizens are Indian citizens regardless of their state of residence. Comparison: unlike the USA and the Australia, which have dual citizenship, India ensures uniform political and the civil rights across the nation without discrimination. Exceptions: residence requirement for employment. Under Article 16, Parliament can impose residential qualifications for specific jobs. The public employment requirement as per the Residence Act 1957 allowed states like Andhra Pradesh and Telangana under Article 371D, Himachal Pradesh, Manipur, and Tripura to set such requirements. Discrimination based on the residence. While Article 15 prohibits discrimination based on various factors, states can grant special benefits to residents. Example: educational fee concessions, protection of the tribal interest. Article 19 restricts outsiders from settling in tribal areas to protect their culture and livelihood. Allegiance. Citizens owe allegiance only to the Union with no separate state citizenship. Eligibility for President. India. Both citizens by birth and naturalized citizens can hold the office of the President. USA. Only citizens by birth are eligible for the Office of the President. Tribunal empowerment. The Ministry of the Home Affairs has amended the Foreigners Order 1964. District magistrates in all states and the Union territories can now establish tribunals to determine if individuals residing illegally in India are classified as foreigners. Certain officers require citizenship. Judges of the Supreme Court, President of the India, Vice President, Governor, MLAs, MPs, Attorney General, Advocate General. Comparison between citizens and these aliens. The Citizenship Act 1955 governs acquisition 5 years and loss of the Indian citizenship 3 years post constitution amendment. This has been amended many times subsequently. Initially included Commonwealth citizenship removed by the Citizenship Act 2003. Acquisition by the citizenship by birth, Section 3, born in India. Automatic citizenship regardless of the parents' nationality. Post July 1, 1987, citizenship if at least one parent is an Indian. Post December 3, 2004, citizenship if both parents are Indian or one is a citizen and other is not a illegal migrant. Executions, children of the foreign diplomats and enemy aliens cannot acquire citizenship by birth. By descent, Section 4, born outside India, January 26, 1950 to December 10, 1992, citizenship if the father was an Indian citizen. Post December 10, 1992, citizenship if either parent is an Indian citizen. Post December 3, 2004, birth must be registered at an Indian consulate with 1 year or with central government permission afterward. By registration, Section 5, eligibility, non-illegal migrants can apply, must take an oath of allegiance and reside in India for 7 years prior to the application. By naturalization, Section 6, requirement, continuous residence in India for 12 years, 11 out of the last 14 years, must renounce other citizenship upon acceptance, must have good character and knowledge of a language in the 8th schedule. By incorporation of the territory, Section 7, when a foreign territory becomes part of the India, the government specifies citizenship eligibility, example, the Citizenship Order 1962, granted Indian citizenship to Pondicherry residents. Loss of the citizenship. The Citizenship Act 1955 prescribes 3 ways, whether acquired under the Act or prior to it under the Constitution. First, renunciation of the citizenship. Section 8, process. A citizen of full age can declare renunciation, which is registered by the authorities. Effect, citizenship ceases upon registration. The process can be withheld during wartime. Mind the children. Children of the renouncing citizen also lose citizenship, but can reclaim it upon turning 18 within 1 year. Termination of the citizenship. Section 9, automatic loss. Voluntarily acquiring another country's citizenship results in automatic loss of the Indian citizenship. Exception, this does not apply during the wartime. Deprivation of the citizenship. Section 10, citizenship can be removed by the government if fraud, disloyalty, unlawful trade, criminal record, continuous citizenship. Citizenship Amendment Act 2090, definition of the illegal migrant. Definition, foreigner entering India without valid documents or overstay is deemed as illegal migrant. Prohibition, illegal migrants cannot acquire Indian citizenship. Citizenship for persecuted migrants. Exemptions, Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from Afghanistan, Bangladesh and Pakistan entering before December 31, 2014 are exempt. Reduced requirement, citizenship requirement for these groups is 5 years instead of 11 years. Exclusion, tribal areas. Exemptions do not apply to tribal areas of Assam, Meghalaya, Mizoram and Tripura. 6th schedule. Inner line areas also exempt are regions regions under the Bengal Eastern Frontier Regulation 1873, Arunachal Pradesh, Mizoram, Manipur and Nagaland.